How's everybody doing? I'm Brian Janflone, and I'm going to start with the Georgia case law update. The first area of law that we're going to discuss is a pretty specific area, and that's the idiopathic defense in Georgia. And we're going to briefly go through some of the history of the idiopathic defense and how it's progressed over time and where we are today with that defense. I'm going to start with the meaning of idiopathic. Idiopathic, according to the Merriam-Webster Dictionary, means arising spontaneously or from an obscure or unknown cause. It's peculiar to the individual. So, for the purposes of workers' compensation, if the injury is idiopathic, it does not arise out of the employment. And here's an example of what we may think of as an idiopathic injury. A lot of times, you think of it as someone fainting and falling onto the floor. So that's what's displayed there. The first case I'm going to talk about is going to take us all the way back to 1935, and it's Bid Manufacturing Company versus Alford. And the facts of this case: Mr. Alford was a mill worker. He tried to call out of work because he wasn't feeling well. He didn't think he was going to be up to his shift. He worked the evening shift in a manufacturing plant, and his employer convinced him to come in because they were short-staffed that evening. So he went ahead and came into work, and about an hour after starting work, he went to get a drink of water from the water fountain, and he fainted and fell on the floor, injuring his arm. He thought the reason why he fainted was from being overheated due to the exertion at work. And back then, we didn't have a state board of workers' compensation. It was called the Industrial Commission, and the commission in this case initially denied compensation, finding the work he was doing was not particularly strenuous. The plant that evening was about 70 degrees at the time of the injury, and then it went up to appeal to the Superior Court. They reversed that decision. Then it went up to the Court of Appeals, and the Court of Appeals found the general rules that an injury arising from a physical seizure not induced or related to the employment is not such an accident that would afford compensation. However, the court did note that consideration should be given to any weakened condition of the employee, which is essentially an aggravation of a pre-existing condition, which we all know in Georgia is compensable. And so they did place importance on the fact that he brought his weakened condition to his employer's attention before he worked that evening, and they talked him into working. And so they essentially upheld the reversal by the Superior Court. The next case I'm going to talk about is the United States Casualty Company versus Richardson. And in this case, the worker suffered an epileptic seizure and fell against the sharp edge of a table. In this case, the court found the fall was not a compensable condition. However, the award of benefits was affirmed because the sharp edge was a special danger of the workplace that presented an increased risk of injury, which essentially means that if he would have just fainted, fallen onto the floor, didn't hit anything on his way down, it wouldn't have been a compensable injury. But because he hit the edge of the table, that made it a compensable injury because his injury was worsened by hitting the sharp edge of the table. The next case is National Union Fire Insurance Company versus Edwards, and this is some sensational facts in this case. The worker was injured after the building collapsed on top of him. The court upheld the award of benefits by the board in this case, and they specifically overruled any prior decisions that found the danger that caused the injury must be peculiar to the work and not common to the neighborhood. And they essentially adopted a new standard here in Georgia, which is the positional risk doctrine. And under that doctrine, the worker must only prove that his employment required his presence where the peril struck, and even though any other person in the area also would have been injured. So if you apply that to the facts of this case, his job required him to be in this building, and the building collapsed on top of him. So that is why this was a compensable case, even though the collapsing building could have hurt someone who wasn't working at that time. This man was working, and he was injured because of that unfortunate situation with the building collapse. The Next case is Warden Foods versus Dorsey. And in this case, the worker was injured as a result of the fall on the floor that was precipitated by a fainting spell. And benefits were awarded by the board in this case, and the Court of Appeals reversed that award of benefits, holding that despite the fact that the injury occurred while engaged at work, it was not compensable because it did not result from something he was doing in the course of his work or from some peculiar danger to which he was exposed. So this is a classic idiopathic case that we think of: fall out on the floor, don't hit anything on your way down. That's an idiopathic injury. That's not compensable. Now we're fast forwarding several years to 2002, Johnson versus Publix supermarkets. And in this case, the cashier was walking quickly, looking ahead for items left on the floor, trying to clean up towards the end of her shift, and she slipped and fell and broke her leg. And the court found this claim compensable, reasoning that if she had not been working, she would not have been hurrying through the aisles, so she could be available to check out more customers as needed. The court also specifically overruled the Dorsey case as inconsistent with the positional risk doctrine established in Edwards. Now, Johnson was a case that really diminished the idiopathic defense here in Georgia. If a person was at work when the peril struck, the resulting injury would be compensable. And it overruled that case, if you recall, board cases where someone just fell out on the floor and injured themselves. Johnson specifically overruled that case. Well, luckily, the court revisited that decision and Chaparral Boats just 2 years later. And Chaparral Boats, you guys may remember this case where a worker was running late for work and they were walking quicker than normal on their way to the time clock, felt pain and popping in her left knee. She did not trip or fall, and according to the board, the medical evidence showed that the injury could have occurred even if she was walking at a normal pace. And the court specifically found this case was not compensable and specifically overruled the Johnson case we just talked about with the cashier, to the extent that it misconstrued the positional risk doctrine and overruled Dorsey. So it made Dorsey good law again. It's getting kind of confusing on which case is good law, which case is not, but for the purposes of what we presented here today, the Dorsey case where the person passes out onto the floor and doesn't hit anything, that's compensable, or I'm sorry, that's not compensable, that's still good law. And the Johnson case where the cashier fell and broke her leg just while she was walking through, that was overruled. And the court clarified the positional risk doctrine in Chaparral Boats, saying it does not require a risk peculiar to the employment. It does require a causal connection between the condition of the employment and the injury. Specifically, in this case, the risk of walking is not particular or incidental to the character of the employment, and walking is a risk shared by the general public. And the next case is Harris versus Peach County Board of Commissioners. And in this case, the worker was a custodian, and the custodian's job at the school included bending over to pick up trash off the floor. And in this specific incident, the custodian dropped a diet pill out of her pocket. Her supervisor noticed that she had dropped the pill, pointed it out to her, and Ms. Harris, the custodian, bent over to pick up the pill. She dislocated her knee. And the court found this claim was compensable. Although bending over to pick up an object is a mundane task that normally does not cause injury, they reasoned that the operative question in this case was whether the claimant was performing an activity in furtherance of her job duties. And it's a little confusing in this case because it was her diet pill that she dropped on the floor. But if you think about a custodian's job description, even if it's something she dropped, it's her job to pick it up off the floor. So the court thought that was dispositive in this case, and they found that this case was compensable. And importantly, to remember in the Harris case, one thing I failed to mention is that the board in this case found it compensable. So the court essentially deferred to the fact finder, which was the board, in this case. So it may have gone the other way if the board had found that this case wasn't compensable, but the board affirmed the decision of the board. The next case is St. Joseph's Hospital versus Ward. And in this case, a nurse went into a patient's room to give him medication, and she turned to get the patient a glass of water to take the pills, and she twisted her right knee. And in the opposite to the last case, the board found that this claim was not compensable. And in this case, the Court of Appeals agreed with the board. Once again, it was not a compensable case. They reasoned that she was not exposed to any risk unique to her employment by standing and turning. They deferred to the fact finder, and they did note in the decision that these are extremely fact-dependent cases. If you think about what this nurse was doing versus what the custodian was doing, it doesn't really seem like there's a whole lot of difference between what they were doing, and it looked like the way the Court of Appeals was going to rule was to uphold the decision of the fact finder. Then we get to Chambers versus Monroe County Board of Commissioners in 2014. An EMT injured her left knee when she stood up from a chair at the request of her supervisor. The board found this case was not compensable. The Court of Appeals, in this case, reiterated the legal standard established in Chaparral votes. The court then noted that the claimant did not stand up from the chair in any unusual manner, so they affirmed the board's decision that it was not a compensable claim. So you're seeing a theme here in these last three cases where the Court of Appeals was upholding the decision of the board. It was the fact finder. They're kind of deferring to the board because of the fact-dependent nature of these idiopathic cases. Well, the next case we get to, which is just last year, Cartersville City Schools versus Johnson. Johnson, again, just like the Publix case, Johnson's apparently bad luck for us, because in this case, the teacher was in her classroom instructing students, and she turned from her computer and desk to walk towards the front of the classroom. She fell, injuring her knee. The ALJ found this claim was compensable. However, on appeal, the board reversed that decision. Then it goes up to the Superior Court, and the Superior Court reversed the decision of the board. Well, here, the Court of Appeals appears to have changed its course, and they found this claim compensable. And that they said that if a worker is actively engaged in movements required by the job and injured as a result of that movement, then it is not an idiopathic injury. And it appears the key and deciding factor will be determining what is required by the job. The court went on to say that idiopathic refers to injuries sustained at work that are unrelated to and do not occur while engaged in work. So that case further weakens the idiopathic defense in Georgia, and it appears that the Court of Appeals is no longer simply going to defer to the fact finder. Over the years, the body of case law for these idiopathic cases has taken many twists and turns, and the court in this Cartersville City Schools case seems to suggest that your injured worker is engaged in any movement required by their employment and furtherance of their job duties, it's likely to be found compensable. So that is where we're at today. That's all I have.
Good morning, I'm Landon Kreider. Everything Brian just talked about, obviously, as you see, only deals with that one section of, or that one issue of the idiopathic defense. There's been several more updates to rules and law in the workers' compensation field. The first being that starting next week, 75 to 675, and this change is being made to reflect what was calculated as about 2/3 of the average weekly wage statewide. So the board did that math and saw that 675 is more appropriate for a compensation rate based on the statewide max, and that TPD rate is obviously 2/3 of that TTD rate. And another change being made is the maximum payout to the sole surviving spouse to $270,000. And those are just made to reflect the average wages in Georgia. Another change that was made is for the medical device and maintenance. And starting July 1st, any non-catastrophic claimant that can seek medical treatment beyond the 400-week medical cap as it pertains to a medical device. We were discussing this yesterday, and it seems even with a knee replacement, since that knee is a device, if the claimant lives long enough for that knee replacement, the artificial knee to go bad, I guess you could say, then we'll be on the hook to pay for the replacement of it again, because this new law requires us to cover the maintenance, repair, revision, replacement, or removal of any prosthetic device, spinal cord stimulator, pump, or any other medical equipment that the claimant was given as a result of their work injury. So that's another big change that's going to affect the exposure on these non-catastrophic claims. Then there's some more case law that's been updated, some notable decisions. First being Ocmulgee EMC versus McDuffie. And the issue in this case was the employer's burden for suspension of benefits, and the employer had paid benefits for a compensable knee injury, and later discovered that the employee had omitted a prior knee injury and permanent work restrictions on his job application. So they fired the employee and suspended benefits. They recommenced TTD after the employee had surgery, but suspended again when he was released to work with pre-existing permanent restrictions. So he got back to that baseline, and the employer suspended. So the issue in front of the court was, must the employer show availability of suitable employment to justify suspension of benefits if aggravation of the pre-existing injury is no longer the cause of disability? And the court said no. When that worker has a pre-existing condition, as soon as the effects of the new injury cease, the employer's responsibility for workers' compensation benefits also ceases. So if you had permanent restrictions of 20 pounds and then you hurt your knee and you're down to 5-pound restriction, once your medical care gets you back up to that 20-pound restriction, the employer can suspend benefits because that was your pre-injury baseline condition. The next case is the Chandler Telecom LLC versus Burdett. And the subject matter was willful misconduct when an employee fell from a cell tower during a controlled descent, rappelling down even though he had been told not to do that, to climb down. So the issue was, does the employee ignoring his supervisor's instruction constitute willful misconduct to allow us to deny benefits? And it was held that maybe. So no compensation is allowed for an injury due to the employee's willful misconduct under the law. But violating rules that are designed to protect the employee is not automatically considered willful misconduct. Willful misconduct is intentionally doing something with knowledge that it is likely to result in serious injury or with the wanton and reckless disregard of probable consequences. So in that case, just because he rappelled down and did his controlled descent rather than climbing down, it didn't automatically make it willful misconduct, because he would have to prove that, or the employer would have to prove that he knew that would probably result in injury, or he was acting with a reckless disregard for his health and consequences. Kendrick versus SRA Track Incorporated. The subject matter is continuous employment and controvert. So the employee sustained his injury on Sunday at 4 while traveling from Georgia to a job site in Alabama where he worked during the week. The employer provided a prescription card used for months. The employer controverted the claim after the employee requested a hearing more than 1 year after the accident. So did the employee timely controvert, and was the employee in the employer's continuous employment when injured? And the holding was yes. Where compensation is being paid, the controvert must be filed in 60 days of the due date of the first payment of compensation. But only weekly income benefits are compensation, not medical benefits. And no, employee was only required to work away from home during the week and was off duty when traveling to the hotel on the weekend. So continuous employment might apply when he resumed his job duties Monday, or perhaps if he was driving from the hotel to the work site, they may have seen it differently because he was in Alabama for the week to work and otherwise wouldn't have, been driving to that site in Alabama. So that was the key fact in that case, was that it was a Sunday drive to work starting Monday. Another continuous employment case was Everett Plumbing Company versus Castillo, where the employer provided a hotel for the week to an employee scheduled to work weekdays. He performed a personal errand on Sunday, and the issue is whether that injury on the personal errand was compensable under the theory of continuous employment, and the court held no. The the employee was not in continuous employment because he was not away from home for a work-related purpose at the time of the injury. And the employer merely provided weekend housing as a personal convenience. So basically the court is saying, no, just because you have to work out of town doesn't mean that everything you do while you're out of town is related to work. If you want to go, to a bar or whatever, do something personal, if you get into a car accident, that's not going to be covered by work because it's not related to work. We have several more cases to go over, and Cherie is going to take over now to give you more of those.
Hello, Landon. You did a great job introducing me. I'm Cherie Tomlin, one of the other attorneys at the office, and I'll start with something that's not really that important to us in this room. The first one is about attorney feelings. In this situation, this is one of those things you'll get for a mediation sometimes after we settle the case. The attorneys, maybe she had a first attorney, then she gets the second attorney, and they go back and forth over who's entitled to the feeling. So this first one is Law Offices of Flores versus Cruz and Associates. We all know Cruz and Associates. So of course the issue is whether the second attorney, which would be Cruz and Associates, is whether they should get the fees or whether Flores should get the fees. The employee suffered a compensable injury in 2005. He signed a contract with the first attorney, and Flores represented her for about 6 years. She got benefits, she got medical treatment for those 6 years. Then in 2012, I'm sure they did something wrong and chose Cruz and Associates over Flores. Flores filed the fee lien for about $17,000. Cruz, in turn, gets the case probably within a year or so, settled the case for $50,000, and Cruz contested Flores' fee lien. The ALJ actually found that Flores, which is the first attorney, was not entitled to payment under the fee contract because there was no meeting of the minds. I thought this was very interesting because generally in workers' comp, as long as you can show that based on quantum merit, you would get your fees, but it's not necessarily a meeting of the minds. So the ALJ still, however, found that he, even though they say there was not a meeting of the minds, they still said there was quantum merit and gave him the full fee lien. The Superior Court said that it was invalid because of no meeting of the minds, which the Superior Court just made up their own meeting of the minds situation. And so the Court of Appeals reversed the Superior Court and said the law is well settled that even if attorneys are discharged, as long as they can show that there was quantum merit for the reasonable value of the services, then they are entitled to their lien. They did, however, say that Flores didn't necessarily show that there was a meeting of the minds. But in any event, as long as they can show that we did work for those services, essentially the income benefits and medical treatment, and that he was entitled to his lien. The next one we have is Davis versus Louisiana. The subject for this one is jurisdiction for an occupational disease claim. The exposure occurred in Alabama, which is, of course, not in Georgia. The contract happened in Alabama as well. The facts of this one is a little different because the employee was employed like in 1984 from 1998. He didn't move actually to Georgia till after the exposure. So in the courts in this case, there was some determination going back and forth with whether there was some exposure or when the injury actually manifested itself. The employee didn't file for benefits until 2015, which is at that time when he's living in Georgia. The employee filed a claim for benefits in Georgia after being diagnosed, of course, and after the death, his surviving spouse and dependents filed a claim here in Georgia. Neither the employee nor his beneficiaries filed for anything under Alabama's workers' comp statute. The ALJ and Appellate Division dismissed the employee's claim that the Georgia Board of Courts lacked jurisdiction. The Superior Court and the Court of Appeal affirmed on the same grounds. I thought this one is an interesting case because it's an occupational disease, whereas had it been, let's say, a motor vehicle accident and the claimant lived in Alabama but had the accident in Georgia, the distinction, of course, would be if the accident actually happened in Georgia, then it will be the claimant's choice to choose jurisdiction. So just I always get a call sometimes where it happened in Alabama, claimant lives in Georgia, or the opposite. Just remember, in most cases, they can choose. It's the claimant's decision as long as their main workplace was Georgia, or if they lived in Georgia, even though the accident would have happened maybe in Alabama. Next, we have Starwood Hotels. The issue with this one, well, we'll start with the facts first. It was a compensable injury back in July 2014 while working for her first employer. She received TTD benefits, she was released to full duty, and then she began working for a new employer in November of 2014. And she did not start that job actually until after she was released to full duty. As most claimants do at some point, if you stop treatment with the ATP, she sought treatment from other physicians on her own. She said that her symptoms worsened after she got her new job. Looked like she stopped working about July 2015. She requested a hearing seeking TTD benefits based on a change in condition. She also sought treatment with her choice of a doctor. The first employer, of course, requested a hearing for a change in condition, saying that they were no longer responsible for the benefits because she had been with another employer, so they were trying to essentially get the second employer on the hook. The ALJ found the employee experienced a change in condition for the worse as of July 2015 and ordered the first employer to pay TTD benefits and medical benefits. The ALJ, interestingly, found that the first employer, had controverted all income benefits as well as medical benefits, in which usually the appellate division will adopt the finding, of course, as Brian stated, of the ALJ's finding and change of condition. But in this situation, they distinguished it because they gave the awarded TTD to be paid by the first employer, but found that the employee was entitled to medical treatment, but not her choice of doctor, because there was no evidence that they necessarily controverted or denied treatment with the ATPs. She was actually treating with her doctor anyway. This one went all the way to the Court of Appeals, and they essentially reinstated the appellate division. The next one is Lingo versus Early County. Jen, the issue here is whether employer is entitled to the presumption when the scientific blood test or the testing used to determine the presence of marijuana, if it was not conducted essentially with the chain of custody. I know sometimes you have these perfect drug tests, marijuana, it was positive. You call us like, hey, we're gonna deny this because it was positive for marijuana. And the first thing we usually say is, do you have the chain of custody? Can you get it to me kind of quick? Because it takes us a good amount of time to try to get the drug test results as well as the chain of custody documents from either the hospital or the lab. What many of you don't know is that most of them come from the lab, so it makes our job 10 times harder because we are unable to get Quest and LabCorp to send us what we're actually looking for. It works a lot better if it wasn't in the hospital. It was more of an urgent care. Generally, we get those back. This one, the employee, of course, was working at a cotton gin. He was behind a truck and he became pinned between the truck. The employer, of course, did their job. They hired a lab technician to conduct the drug test. She was not, however, allowed in the operating room. Next, the sample was obtained. It was a urine sample, and the analysis of it, of course, revealed the presence of marijuana. The employee presented some evidence that the sample did not provide evidence of whether he was impaired at the time, because essentially he's trying to argue that he was a cotton gin feeder. Him being either using marijuana or under the influence of marijuana did not affect his cognition to do his job. The ALJ found the presumption that the accident was caused by the employee's use of marijuana did not apply in this situation because the employer and insurer were unable to identify who obtained the urine sample. Again, it goes back to the chain of custody, which is why those documents are so important to us, because if we actually went to a hearing on it, we would definitely need those chain of custody documents, i.e. an affidavit from the LabCorp person, the actual documents to present it to the ALJ. The ALJ, however, found the accident compensable and awarded benefits. The appellate decision in this case reversed and denied benefits, finding that any defect in the chain of custody went to the weight. So essentially it would come in, but it would be up to, the judge to decide whether it should be, given much weight or not that much weight. Essentially, if they had additional evidence that showed that he was impaired, then maybe it would be beneficial. The Court of Appeals vacated the Superior Court, I skipped the Superior Court. The Court of Appeals vacated the Superior Court's award and remanded it to the Appellate Division, that the Appellate Division considered without application of the presumption whether the employer satisfied the burden of proving that the employee was impaired. So the Court of Appeal basically said, maybe you get the presumption, but at the same time, you have to show that essentially whatever they were doing caused them, the marijuana impaired them in some way of doing their job. Our next one is Fred versus State Farm Employee Workers' Compensation. The issue here is the distinction between, a scheduled break exception as well as the ingress-egress rule. When there is, of course, in this situation, there was no dispute that the employee's accident occurred while on a regularly scheduled break when she was leaving the employee's premises. I know we always have those cases sometimes where you have, someone's leaving or they're coming, or we don't necessarily know what they're actually doing, but they were going down the steps after they left, let's say, the hospital. If the steps are the only way, that would kind of be considered sort of an ingress-egress, and of course, most times the courts have found that that's compensable. But in this situation, she was on a scheduled break and she slipped and fell while leaving the break room, but she was going outside to eat lunch on her own. The ALJ in this one awarded benefits relying on ingress-egress. The Appellate Division, however, reversed, finding that although the injury occurred in the course of employment, the injury did not arise out of employment because she was actually on a regularly scheduled break and she was leaving the premises to attend a purely personal matter. The Superior Court affirmed the denial of benefits in the employee appeal. The Court of Appeals affirmed but urged the Supreme Court to resolve an apparent conflict in the case law. I think the Supreme Court just said, we're not going to go with this. We're going to leave it alone. If she was going, on a personal matter, even though she was outside her break and she wasn't necessarily going to do something for the employee, then we just go ahead and go ahead and deny. The next one we have is Ware County Board of Education versus Taft. This one is about wages. Taft was essentially a school teacher who worked for 220 days. His pay was prorated over 52 weeks. They generally work over a year. They are off on the summer. His weekly earnings, a portion of his weekly earnings would tell each pay period. The amount was paid during periods of the year in which he was not working due to holidays or break. He suffered a slip and fall to his right shoulder, and of course it was an accepted claim. TCD was commenced based on the actual prorated amount. He was receiving 52 weeks per year rather than the amount he earned per week, including the withheld portion, which means that one was less than the other. If it was the prorated portion, of course it was less, and of course we attempted to use the prorated portion. So the issue was whether his disability should be calculated based upon the actual prorated pay he receives, or should instead include the portion that he has worked to earn, but is deferred from each pay period. The distinction in this one is kind of what he earned as, and versus what he actually made. The OCGA 349260 provides if the employee, of course, is working and employment is the substantially whole of 13 weeks immediately preceding the injury. I know sometimes we have questions about what is the substantial whole. Case law has shown that substantially the whole, if there are more than 2 weeks of zero pay, then we would definitely need to switch over to either whatever his hired wages or as the wages of a similarly situated employee. So the court said that even though the claimant was paid $311.38 per week, his actual earnings during the week, 13 weeks before the injury, are $334.03, which would be what he actually earned as opposed to what he was paid. The claimant's proper average weekly wage was calculated based on his earnings rather than what he was paid. In this situation, they went with the higher rate. And last but not least, we have Kill versus Legend Brothers. In this one, Kill, he was a restaurant manager who lived with his co-workers and the restaurant owners. After returning home from work each day, he had it was his practice that he would spend about an hour or more reviewing the restaurant daily sales. He reviewed receipts, he reviewed accounts and inventory. Maybe an hour and a half, 2 hours at tops. On May 19th, 2016, when he got home, 3 men robbed him and shot Kill in the forearm. He, of course, underwent several surgeries, and he remained out of work after that time. The issue was whether his injury arose out of it in the course of his employment. Of course, initially you would have got these facts and be like, oh, we need to deny that. He got shot, we have nothing to do, he's made it home. This is not within those 30 minutes or 20 to 30 minutes of his drive home, if of course he's on call. But in this situation, the analysis was his key job responsibilities as a manager was to spend time about an hour every day. He and one of the other co-workers, they would go over the restaurant's daily sales, inventory. So his job responsibilities had not yet ended essentially for the day. The court said that on the day that he was robbed, he was still undergoing some job responsibilities. He and his other co-workers did not take any personal detours on the way home that night of the robbery. Thus, there's evidence showing that he was exactly where he was expected to be and in the act of continuing to perform his job duties as a manager. Also, that he was in the course of fulfilling those job duties for the employer at the time of the robbery. His pattern of behavior with regard to bringing everything home was the reason that they knew when and where the robbery. So essentially, the court thought that his actual actions for the employer or what caused the injury. They knew, of course, that this established a causation link between his duties as a manager as well as his injury from the robbery. The court held that his injuries did arise out of and in the scope of his employment. So even though it sounds like a gunshot, at your house would definitely not be compensable, I think the court definitely, this is one of those highly fact-driven cases, and the court thought that he was still in the course of employment.
Yeah, you gotta look at the facts of that case where he was living with the owner of the restaurant and he was going over these receipts after work with the owner of the restaurant. His employment had essentially continued until he got home, and that's when the robbery occurred. So it's really fact dependent. I don't think that's one of those cases that now, like, every person who does any work from home ever, if somebody breaks in their house and robs them, that's going to be a compensable injury. It seems really fact specific.
Especially not lawyers who are doing work from home.
Exactly.
Never going to be covered.
Because if that's the case,
Yeah, we're always
anything
on
can happen, and I'm gonna call Moore Ingram Johnson Steele. Like, look, they robbed my house. I was working.
That is TTD.
I'm gonna need TTD. I'm sorry.
What that
And
means,
and as a side note, Rodney would have said deny. He don't care. He would have said deny it. We're not doing that.
Employer tried to deny this case flat out. They tried to deny the case flat out.
Yes, initially.
Yeah, as we all would, right?
I mean,
if somebody
I
gets
would
shot
do
at
it.
home, we would say that's a denial, but then the facts ended up showing that he
And-
was doing this really specific thing at home with the owner of the
And
restaurant.
also, why they point up the hour, because I mean, within 30 minutes, maybe they would have said something, but it was like an hour and some change. It wasn't even like 30 to 40 minutes. It was the time frame, the fact that he was living, that's what they pointed out. He was living with two other employees, and they were actually going over work, and then they knew that this was his practice, apparently, the employer.
Yeah, that was an important fact that they made it point to point out, that because they didn't stop by Walmart or get gas or whatever on the way home, those robbers knew exactly where they were going to be at what time based on his pattern of behavior to get home and count the money and receipts and stuff. So every little fact mattered in this case, and like Brian said, I don't think it's going to be some blanket working from home thing.
I'm trying. Any other questions?
I don't think it's worth getting shot.
Thank you.
Thanks.